Hi there, my name is Carrie Lutringer, and I'm an attorney at Wadler, Perches, Hundl, and Kerlick. Now recently I had a client come to me with some concerns about a contract that she had signed for the purchase of some real property. And the deal that she had made with the seller was basically that she would pay a lump sum up front as a down payment, and then she would make monthly payments of principal and interest for some period thereafter. Now when the entire amount of the loan was repaid, including all accrued interest, at that point the seller would convey title from seller to buyer. Now my client was concerned that if she fell behind in payments during the term of the loan, or if she was to otherwise default or breach the terms of the contract that she had signed, that she would be at risk for losing her interest in the property. Now this type of transaction is called a contract for deed, and it differs from the standard seller finance transaction in a couple of different respects. So with the traditional seller finance model, the seller at the time of closing will convey title to the buyer by using a warranty deed or some version of a warranty deed. Now, a warranty deed basically is a deed in which the seller is making certain representations and warranties about the quality of the title. Now, in this type of transaction, the seller is going to retain a vendor's lien. Now, what a vendor's lien does is it acts as a security interest in the property, which basically allows the property to serve as collateral for the loan between the buyer and the seller. And typically in this type of arrangement, the buyer is also going to sign a promissory note and a deed of trust to further evidence the lien. So if the buyer were to default or to fall behind in payments, then the seller has an option to foreclose on its lien. But first, the seller has to comply with certain regulations that are promulgated under Texas law, including by providing certain notice and cure periods, by making certain postings with the county clerk, and there are a number of steps that need to be followed before the foreclosure process can be initiated and commenced. This is typically the preferred method for a buyer because the title is transferred up front and it's just subject to a security interest that is held back by the seller. So with my client, obviously this is not the arrangement that she had entered into. So her next question to me was, what can I do to protect my interest in the property? And the good news is there are a couple of things that can be done. The first is to record the actual contract for deed in the real property records in the county in which the real property is located. And this has the effect of essentially converting the contract for deed into a warranty deed with vendor's lien. So if she were to fall behind in payments or default, then the seller would have to comply with all the foreclosure requirements that I previously described before he could potentially obtain title to the property again. The other thing she can do is she can request an annual accounting. This is a requirement under Texas law. If it's requested by the buyer, the seller has to provide certain information about the loan. For instance, how many payments have been made, how much has been paid towards the loan balance, and how much is left remaining owed on the loan balance, and how many payments are still left to be made. In addition, they've got to provide other financial information regarding property taxes and the like. With the contract for deed, if there's a breach of the contract, the seller still has to provide notice to the buyer, either by registered or certified mail. And they've got to provide the buyer with notice of how to cure the breach or remedy it. And the amount of time that they would have to make these corrections or the cure period is going to be based upon the actual status of the loan. So if the buyer has made less than 48 total payments or paid less than 40% of the total outstanding purchase price and has not recorded the contract for deed in the real property records, then the buyer has 30 days to cure. And if the buyer does not cure within that time frame, then the seller can cancel the contract for deed and take back the property and then initiate eviction proceedings to force the buyer to vacate the property. So essentially the buyer is at risk of losing all of the equity that has been paid up to that point. Now, if the buyer has made more than 48 payments or paid at least 40% of the total purchase price, or has recorded the contract for deed in the real property records, no matter the status of the payment, then the buyer will have 60 days to cure. And if not, the seller will have to initiate the foreclosure process by providing all the necessary notices and posting requirements as I described before. So for my client as a buyer, this is probably not the type of structure that I would have recommended. In some situations it may make sense, for instance, if the availability of traditional financing is not there, or if the financing terms that are being offered by the seller are particularly attractive, maybe it makes sense. But if at any rate, if you've got questions about this type of arrangements or you'd like to discuss it in more detail, feel free to contact me or a colleague here at my firm. Our website is www.wphk-law.com. Thanks so much for your time.